Good evening, Sean S. We are a little bit early. Starting 3 minutes early today. That's all right. Early birds get to ask the questions first. I should do the intro. I am Vince White. I am an employment attorney on this channel. We answer publicly posted questions from YouTube users, getting folks the answers they need from an employment attorney. Boy, you can really tell I just went to the gym. I'm a little flush. It's all right. So I just got the live stream started. People will start throwing questions in the chat. I'm going to take a minute, do a couple typey things, but I'm here and I'm ready for your questions. I can't wait till we get some folks on a Friday afternoon. Hopefully there's people that I can help. Oh, hello. I am back. It looks like we have some questions. We have a statement from House Bulldog 1122. Says, hello, I appreciate so much your videos. They have been such an encouragement. I'm really glad to hear that. I'm super glad to hear that. I hope that the videos are helpful. I hope they're encouraging. I know that I can be like a fractious, conflict-oriented person, so I hope that that I give value at least. Not my name says good evening. Good evening to you. Kings52 says, I got a question. Kings52, ask away. We are in fact here to answer questions about employment law. Sean S says, someone at the EEOC put in the wrong employer address and the incorrect information. Instead of retaliation, they put ADA. How does that affect my case? The information I gave is right. Is right. Theirs isn't. So Sean S, I would contact the EEOC and address their failings right away. So first off, you're not going to get a position statement and you might not even get a response if there's not a correct address for service of the employer. So I'd take care of that right away. And then, yeah, you want all of your claims. So like if you have a retaliation claim, great. That's wonderful. You may, you certainly want to include that. But if you have an underlying ADA claim, you want to include that too. You want to include as many claims as are viable, because you don't want to get to federal court and have somebody say, hey, you can't bring that claim. You didn't plead it at the EEOC, right? So you're going to have to amend, Sean S. You're going to have to reach out and get them to fix that right up. Choose Compassion. YouTube user Choose Compassion says, good evening. Good afternoon to you. I do think you should choose compassion. I am not good at choosing compassion. I lack empathy. I'm a failure, but you are giving good advice. Zero Senior says, hi, love your channel. Thank you so much. Very helpful. Thank you so much for saying that. Should I hire a lawyer before mitigation starts? Zero Senior, I would argue that you should hire a lawyer as soon as is humanly possible. Let them add value and reduce risk all the way through. And like, keep in mind, you don't pay them more, right? Like if you're working on a percentage, if you hire the attorney day one, it's generally going to be the same percentage as if you hire their attorney 18 months in the day before trial, right? I mean, it's the same percentage. Nobody's going to take on a trial for a lower percentage because somebody was pro se the whole way. Like that's just embracing a whole heap of risk. So you might as well get them in as soon as possible. Choose Compassion says the DHR, which I assume Choose Compassion might mean the New York State Division of Human Rights, admitted they handled my mediation terribly. Is there anything I can do before the settlement is drafted and sent? They are also including a confidentiality agreement. Okay, so listen, I don't know what you agreed to, but if you agreed to a settlement, it is possible you can get out of the settlement if it's not executed yet. Now, that's iffy because if you agreed to a term sheet, it's possible the other side could try to enforce it. It's also possible if you blow up the settlement, no one will talk settlement with you again because they won't trust you to settle in good faith. I don't know what went wrong in your mediation. If you want to give us a little bit more about what the DHR thinks they did wrong at your mediation, I'd be thrilled to answer that question with more depth. I don't know if it's a good idea or a bad idea to get out of the settlement. We represented by counsel. Also, you'll notice that I'm going mute here every now and then. I have a little mute button on the microphone because I got this cough. Seeing a specialist about the cough next week. I know the cough. It's terrible. I'm doing my best. So Choose Compassion. If you give me a little bit more, I'll try to give you a little bit more. Okay, you're pro se. So yeah, tell us a little bit more about what went wrong in the mediation and why you feel the mediation was a bad result. And I can try to give you an answer. Just make sure you don't identify yourself, right? King 52 says, King 52 sounds like a football call. King 52, Omaha. Huh! Sorry. Anyways, my last employer never paid me for the work I did as a trucker. I submitted a complaint to the Department of Labor, but it's been over a year. Still haven't received a payment or an update on my case. I would call the Department of Labor. I assume you're contacting your state's Department of Labor. I would call them. Listen, every state's Department of Labor is a little bit different, but generally the vibe with the state departments of labor is that, yeah, they do collect, generally speaking, unpaid wages, but they do it incredibly slowly. That's why people still sometimes hire attorneys. You can't hire us to do it. Like, I just don't think it makes sense to, if you're owed less than 40 grand and you're hiring us to collect it, like it's not right. You're giving us too much of that to collect it when you could have it collected for free by the Department of Labor. Although admittedly they might take years to do it for you. Crystal Bell Soccer Ball says, can I reach out to the NLRB after a settlement from the company through the NLRB? If the company is now delaying in granting ADA accommodations, or is that now retaliation under the ADA? So, Crystal, it's going to depend on what you think is going on. If you think you're experiencing retaliation in terms of them not granting your accommodations for the ADA because you filed with the NLRB, then it would be appropriate to contact the NLRB and maybe file something again. If you don't think it's retaliation for filing an NLRB, then the correct avenue to go is probably to contact the federal EEOC, the Equal Employment Opportunity Commission, which would adjudicate ADA claims and retaliation flowing from ADA claims. Now, you may also want to contact a state agency or consider filing in state court or federal court. Check with local counsel. Zero Senior says, you're awesome. Thank you so much. I will take your advice. I did not give you legal advice. I don't know what I said. Oh, yeah. I just said you should hire an attorney early. That's good advice. That's not legal advice, but that's good advice. Oh, it's a flower. I'm sorry. I'm sorry, Crystal Bell. It's a flower. It looked like a soccer ball on the screen. I'm sorry. Daniel N, YouTube user Daniel N says, is a suspension from work as a response to mentioning taking medical leave for my disability considered an adverse action? Yes, especially if it's an unpaid suspension. Choose Compassion is giving us a little bit more detail on what happened in the mediation. Choose Compassion says, I was pro se. They spoke for me and didn't include my statements. I failed to communicate what I said. They're basically asking what if they can resolve it. Probable cause, sexual harassment, discrimination, retaliation. I just wanted the remainder of my medical bills paid. Got it. So my question to you is, if you settled at the mediation, someone offered you something and you said yes. And my question to you is, what changed? Right? Someone offered you something and you said yes. And I get it. We might say yes in the moment and then regret it later. But you must have had a reason for saying yes at the time. So my question is, what changed? So you're saying the respondent was proven liars in the position statement. I get it. Listen, sounds like you had a strong case. Respondents were liars. But I think you probably knew all that when you agreed to settle. So what changed for you? And that question of what changed, that's going to help us determine, what changed is the mediator didn't mention the bill. Okay, so they offered you money and you said yes, and you're frustrated the mediator didn't mention the bill. So you said yes to a settlement thinking the bill was getting paid in addition to what you're receiving? Is that what we're dealing with? And that's just I'm just asking questions, Choose Compassion. I'm trying to get the full read on the situation so I can give you some kind of real thought. All right. While we wait for Choose Compassion, we'll just answer some other questions here. Zavilat says, I'm sending a rebuttal to my employer's position statement. What is a good way to start my closing paragraph summary? Zavi, we have a rebuttal 101 video. That video is very in-depth. It's going to have a lot more information than I can provide you in this video, or in this live stream. Because in the live stream, you're getting like 30-second answers. And that video, I think it's like 30 minutes. Zero Senior says, EEOC mediators, are they any good or professional? Are they trustworthy? Okay, Zero Senior, here's what I will tell you. Deborah Reich in New York City is the sun, the moon, and stars of EEOC mediators. She is fantastic. She cares. She helps people. She's incredibly professional. She's a great mediator. On average, most EEOC mediators may or may not be able to read. They are slimy, lazy, disgusting human beings who don't give a fuck about you or anyone else. But they also, in fairness, don't give a fuck about the employer. I should stop swearing. Now, all they care about is getting everyone to say yes to some agreement. They don't care what the agreement says. They don't care who's made whole. They don't care who gets help. And they will say whatever they can say. They will do whatever they can do. Like I will tell you flat out, after mediation at the EOC, I would get in the elevator and I would talk with opposing counsel, and opposing counsel would be like, did they tell you that you had no case and it was all trash and they could tell your client was a liar? And I'd be like, yeah, that's what they said. Is your guy going to lose 30 mil? Is that what they said to your guy? And defense counsel's like, yeah, no, it was 25 mil this time. And these mediators, they just don't care. They will say anything. They will disclose anything. Like, you got to be careful because you have to say things to mediators. You have to disclose some things, but they might tell you they're going to keep it confidential. But are they? So that's my thought, Zero Senior, on EEOC mediators. House Bulldog 1122 says, does an NDA from an employment lawsuit prevent me from speaking to a therapist, medical provider about past traumatic experiences? No, it does not. Can my past employer get me in trouble for talking to a medical professional? No, they cannot. At least I've never seen it. Listen, have local counsel review your NDA. I don't know what your NDA says, blah, 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 blah. But I've never seen an NDA that would prevent you from speaking to your medical health professional or your mental health professional. YouTube user Yos, YOS, says, would a form of retaliation be for the employer to hire a third-party agency auditor to choose an employee 403B retirement plan for review after submitting a discrimination complaint and investigation? Probably not, unless it was your job to pick the 403B retirement plan. So like if you're saying like you filed a complaint, discrimination complaint, and then the employer hired a third-party auditor to choose a 403B retirement plan for everyone, then that's probably not retaliation against you, right? Because it was for everyone. Now, conversely, if you're saying like, hey, I was the employee whose duty it was to choose a 403B retirement plan, and they stripped me of my duty and gave me nothing to do and hired a third-party person to do it, then yeah, that could be a retaliation. YouTube user Not My Name says, what do you do if claims aren't exactly correct in an acceptance letter, and if you get questions when investigating is not accurate? So if your claims are not correctly set out in a letter, I would urge you to make sure that gets corrected. Having an accurate narrative that is the same over time in terms of what you're complaining about is very important for you, both in terms of protecting your rights and securing, statutes of limitations and making sure your claims can go from the EOC to federal court and so on and so forth, and also protecting your state law rights and your local law rights, right? That can be important all the way through. But it's also important to maintain that narrative consistently across the board, because you don't want at trial someone going to the jury and saying, well, back in June, Not My Name thought such and such was his or her claim, but now here we are today, 11 months later, and YouTube user Not My Name says the claims are something completely different. Why can't YouTube user Not My Name keep their claims straight? Right. And they will do that. They will absolutely do that. And it's a viable strategy. They would certainly try to do that. Choose Compassion says that during the mediation, there was an additional bill and that was not included in the 16K. So Choose Compassion, if they told you that the additional bill was included and now it's not included, you just have to say like, hey, you told me I agreed to a settlement for 16K plus this bill. So whatever settlement agreement you give me better include 16K plus this bill getting paid, right? Now, if they misled you on that, just stand your ground. If they didn't, and they just said, hey, you can accept a settlement of 16K, and you accepted that, and now you're just later being like, and I want this bill as well, I don't know how it's going to go, right? That one's tough. It depends on like how big the bill is, right? Because if it's 16K plus a $20,000 medical bill, well, you've more than doubled the settlement, and that settlement's probably breaking down. That's probably going nowhere, right? I could be wrong. I'm just saying that's my guess. Crystal Bell says, yes, get a drink of water here. Yes, the NLRB helped rescind a performance improvement plan my manager tried to give me after the accommodation request. Now, my manager is over-documenting every mistake I make while in the interactive process. I don't, in all honesty, understand why the National Labor Relations Board would be involved in an accommodation issue. I assume you're talking specifically about an accommodation for a medical issue. That would generally go to the EEOC. So I don't know why you were filed in the NLRB or why they helped you for that matter. But my take would be like, hey, if the NLRB is actually helping you, contact that investigator again, but also file with the Equal Employment Opportunity Commission, because your statute of limitations can be quite short at the EEOC, either 180 days or 300 days for private employees, and even shorter for federal employees. So, consider getting that filed as well, because that would be the proper venue for that complaint. YouTube user Jill Nojak says, can I tell the company to send my settlement check within 7 calendar days at my mediation? No. Well, I mean, it depends on the jurisdiction, but generally in most jurisdictions, no. It appears that the company has been stretching the action out for several months. Jill, you can, like in New York, I think it's 28 days. And that's generally the standard because of some issues, some waiting periods set out by the law. YouTube user PoGirl2011 says, What are the best points to bring up in a consultation with an attorney regarding a failure to accommodate and retaliation claim? Pogirl 2011, we have an entire playlist of videos on how to pitch your case and how to hit the high points of your case. I would urge you to watch those many videos. I think there's like 30, 40 videos in that playlist that will help you learn to pitch your case to attorneys. It's going to be way better than I can provide you in this moment here. The quick answer I'll provide you here is the best parts of your case. What are the best parts to help you prove your case? The best parts to help you make the case valuable. Include those. Zero Senior says, thank you so much. You're my hero. I think you can do better. I think you could have a better hero. I'm aggressively mediocre. I think you can do better. Like I would be uncomfortable if I was your hero. I just suspect you can do a lot better. YouTube user Chris Ritchie says, if your employer files bankruptcy, goes under and liquidates, what happens to the status of your documents you sign, and can you badmouth your former employer? So it depends. If they go bankrupt and someone purchases them and purchases all of their rights under the agreements you were subject to, then they may still be able to enforce those agreements. If nobody purchases those rights and there's no entity that exists to enforce those agreements, then there's no one to do it. And you would probably not face enforcement, but I can't tell you that for sure. YouTube user Yoss says, what happens to an employee if an employer hires a third-party agency to investigate discrimination complaint and they found no discrimination? Can the employer fire you after the findings? No. So you still made a good faith complaint. If they fire you, that's a retaliation claim. Choose Compassion says, BTW, I am a subscriber. Thank you so much. I love subscribers. The mediator didn't include the one bill for $16K. Your videos helped me. It was similar to your video of offering $10K jumping to $50K, hypothetical. Thanks. You got it, Choose Compassion. I really hope I helped in some way. Yas, if you were picked randomly by a third party to review your 403B plan, if it was truly random, probably not retaliation. I also don't know that review of your plan would necessarily hurt you unless there's something going on. But if you can state a specific way it hurts you and it's very suspicious, then yeah, it could be retaliation. My other YouTube user, my other channel, hello, my other channel, asks us, what are the main deciding factors in filing a rebuttal at the EOC or asking for the right to sue and going straight to federal court? I mean, the simplest one is risk tolerance, right? And also your desire to be public. So what you file in federal court is going to show up publicly. It's going to be available on Google, background checks, everything. The EOC, much less so. So if you want more time to duke it out at the EOC and push settlement, you file the rebuttal. If you don't want that and you want the big show, you want to go to federal court, risk it all, let's have it out, then you pull and you get your right to sue letter. Poor Girl 2011 asks us, how often do you see systemic claims with the EOC? My claim has been in investigation for 2 years. Are you asking me how long I see the EEOC handle a systemic claim? They actually keep a list. They post a list of all the claims they handle, including the systemic claims, every year. So you don't need to ask me necessarily. You can see for yourself the claims they bring. I suspect when you look at the list, you will say, this is not a lot. And you are correct. Poor Girl 2011 also goes on to say, also, the employee is still in the hostile work environment and has been continuing to report to the EOC for the last 2 years. What happens if the employee's symptoms are worsening? I would hire an attorney. It sounds like your case is just languishing in the EOC and nothing is happening. I would hire an attorney immediately. Sean S. says, how is it determined where a case will be held? Can the trial location be requested? A Bronx courthouse. So listen, if you worked in the Bronx, you can probably bring that case in the Bronx. If you didn't work in the Bronx, you're probably not going to get away with it, right? So that where you work is the biggest determining factor. Also, the convenience of the parties, the efficiency of the courts. There's a lot that goes into it. But if you file in a place where there's no reason to file, you might have a bad time unless everybody's fine with it. YouTube user Chris Ritchie says, how come employment lawyers never go after the toxic bosses themselves for their wrongdoing? So, Chris, that's super simple. Most toxic bosses don't have deep enough pockets for us, right? So when you come in and hire an employment attorney, you're asking us to spend between 10 and 140 grand on a case on average, right? Like, depends on how far the case goes. The case goes Federal court, how many expert witnesses you need, how many attorney hours you need, how many resources, do you need forensic IT? Like there's so many different ways that a case can like be more or less expensive, right? Is there 600,000 pages of documents, right? Do I need to go get a breakout center and do deposition coding and document coding and all these additional resources on a case, right? So, you know, 10 to 140 grand, I would say, on a case on average. Certainly, I've seen it go higher. There's not that many bosses that can pay you enough if we win the case for you that we could even break even, right? The employer, we know what they've got to some extent. And we know we can collect. We know where they live. The bosses, I don't know what they have. I could hire people to figure it out, but odds are it's not that much, right? Like when I have an individual defendant who's worth a great deal of money, I do in fact intend to include them. But your toxic boss is probably having trouble paying off his Camry. So if I sue him and spend a bunch of money on it, or her for that matter, is that a smart investment for me? The answer is no. Now, where I depart from that logic is when you want to divide and conquer, right? So if you start going after some individual bad actors at a company, in certain situations you can, right? And they freak out and they want to settle with you and they want to become a witness, you know, they want to give affidavits, whatever it is. Certainly you can't do anything improper, but if the employer is not making that individual defendant feel safe enough, you can really drive that wedge, right? And that can have some real tactical advantages. So that's the situation where I say do go after the individuals. Most of the time, listen, you just can't afford to. YouTube user Steve's True History and Knowledge channel says, can whistleblower retaliation cases for fraud get settled, or do they always go to trial? Depends what kind of fraud, depends what kind of evidence you have, depends where they're going, depends who got defrauded. The federal government got defrauded, those settle all the time. If individuals got defrauded, I don't know. That might not get settled. YouTube user Choose Compassion. I thank you kindly. You're more than welcome. Based on what I've learned from your channel over the years and today, I know what to do. Chat, I highly recommend watching all the playlists. I think the playlists are great. We work hard on the playlist. And like when people criticize the playlist, I go back and try to fix it. Oh, sorry. Chat jumped ahead real far there. Okay. Crystal Bell says the NLRB, the National Labor Relations Board, was involved because my manager said we can't talk about pay, and the company settled by giving us a letter saying that we are allowed to talk about pay. Got it. Crystal, I would really go to the EOC. Oh, okay. So the NLRB saw the performance improvement plan as retaliation for your NLRB complaint. Yeah, I would go to the EOC with this, in all honesty. Exec Monster X says, hi, Vince. Is a signed declaration valid in court if it's not notarized? It's not as good. Not an affidavit, I'll tell you that right now. Listen, a sworn statement's better than a written statement. What you've got is just a written statement that somebody signed. But it, you know, not as good as an affidavit, sworn and notarized. I'll tell you that. Doesn't mean it's not evidence. Still can be evidence. Still has evidentiary value. It's just not as valuable as, you know, an affidavit. Philip Casada says, I got a letter from the California Civil Rights Department saying that it has been 150 days and I can request a right to sue or have them continue to do their investigation. What should I do? I don't know, Philip. I don't know anything about your case. I don't know about your risk tolerance. I don't know what your goals are. I would talk to an attorney, a local counsel. I mean, that's the best thing I can tell you is talk to a local counsel and have a conversation about your goals, the risks in your situation, the leverage you have in your case, the various venues you could bring your case in, and what's the best fit for you holistically. Disguise 2023 Safety says, is it standard practice to make the spouse sign a non-disclosure disparagement clause? No. without any compensation for spouse, specifically in a private mediation. No, I can tell you that is rare. I have seen it. I've seen it where specifically, I mean, a couple situations, specifically spouse was big on social media, spouse was a reality TV star, spouse couldn't shut the F up. Like situations like that where the defendant knows that spouse is absolutely going to just run their mouth. That's where that comes up, in my experience. Zero Senior says, how often do you have your live chat? Every couple of weeks. It's hard. It's hard. I got to put my clients first. Do you have a schedule that I could plug myself into to be able to chat with you? No, not really. I mean, I try to do Friday afternoon. I try to do Friday afternoons, but listen, if a client needs me, I help the client. Right? This is what I do to kind of give back, and I give back when I can, but I often can't. Real quick, we have 31 concurrents. We only have 13 likes. That makes me sad. The likes are how people see our stream. Please, folks, if you like it, click the button. What do we have? Whoa, chat is jumping. Porgo 2011, thank you for always willing me to help. Listen, I'm always willing to help. I wish I could help more. Choose Compassion asks, is it standard practice for non-disclosure agreements to be part of the human rights or EEOC settlements? It is in New York right now. Yeah, the New York state laws that kind of mess with confidentiality agreements and settlements are pretty defunct, and 9.9 out of 100 of them will have confidentiality or non-disclosure agreements in them, in those settlements right now. Yeah. Chobi Chav says, what happens if the employer doesn't respond to the position statement by the deadline? My investigator said he sees this all the time, so he called and emailed them for the position statement again. Not much. If you're in the EOC, the EOC is not going to do much. They're just going to issue a right to sue letter because the employer is not responsive, and you're probably going to have to go into federal court. Steve's True History and Knowledge channel says, is it true that most cases get settled for less than $50K, and do the lawyer's fees come out of that? That's absolutely true. Yeah, I mean, it depends on the venue. Very much. That's not, I suspect, true in federal court at all, but it would be true. I think the State Division of Human Rights in New York, I think the number might be closer to 40K, frankly. It does change year to year. Listen, there's different kinds of cases, right? There's a lot of cases that just aren't cases or nuisance value cases. So there's tons of people out there filing cases that are just trash. They don't make any sense. They're not discrimination. They're not really sexual harassment. I'll give you an example. There was a case where I saw this recently. An employer had like a company event, and at the company event, people drank too much, and there was a lot of like sexual harassment issues and everything else. And the employer responded correctly. The employer did everything correct, punished the bad actors, but they also instituted a policy like, hey, no more drinking at events. And someone filed a claim against them saying you're victim blaming by saying don't drink at events anymore. You're making it the victim's fault that the sexual harassment happened. And the employer's like, no, we just don't want sexual harassment to happen. Everybody drank too much. You're all not that professional. We're just not going to have drinking events anymore. And this person's like, no, it's victim blaming because you don't want them to drink. You're blaming the people who drank, the victims. And it's like, that is the dumbest claim I've ever heard, right? Like that, the employer's just like, hey, bad things happened. We're taking steps to correct it. We think we punished all the bad people, but we fear if there's another drinking event, more bad things will happen. So we've decided no more drinking events. And somebody filed a claim against them. That claim, I think, settled for like $2,000 because it's stupid. It's a stupid claim. The person who filed it is kind of an asshole, right? Like it just is what it is. So that average, that like 40, 50K average of settles, like of cases, like it's heavily dragged down by this huge bulk of trash cases that settle for like $1,000, $5,000, whatever it is, you get into a case and it's just not what you thought, or it's not, people lie, or things aren't really true. And, you get these smaller settlements and it really brings down the average. Zabi Lot says, is the EOC required to send exhibits when they send the employer's position statement? They are not required. I noticed their letter says they do not authorize the agency to release their position statement or any docs. So they can't. So if you FOIA request it, you can get all of that. There's nothing the employer can do to stop you from getting that if you file a FOIA request. Also, the EOC will absolutely give you the position statement. That's not, the employer can say, don't give the position statement, but you have a right to draft a rebuttal to the position statement. So that's right off the bat nonsense. The attorneys for your employer are stupid. They don't know what they're doing. The exhibits, though, yeah, the EOC will sometimes not turn those over, and you just have to file a FOIA request to get them. Choose Compassion says, I can't imagine how many times per day you were asked, what should I do with that information? Yeah, so I mean, that is an issue. Like, it's hard to tell somebody what to do. Like, getting to the bottom of what's going on in a case usually takes a couple hours. So this is tough, right? I can give generalities, but I can't be like, hey, you specifically should do X, Y, and Z, because I don't know anything about you or your situation or the tactical set in your case or anything else, right? Or even what your attorney is capable of, Exec Monster X says, what are the limitations of a declaration in difference to an affidavit in court? So it's not like a hardline rule. It's just more evidentiary value. An affidavit is a sworn statement, so it's worth more as evidence. A written statement of recollection or something like that that's signed but not sworn to is just worth less as evidence. It could be viewed as less compelling, certainly by the court or the finder of fact. And, I mean, it really depends on how you build it up. If you can really substantiate it, if you can build like a big foundation for that piece of evidence, you might really make it valuable. Steve's True History and Knowledge Channel says, sorry, yes, government fraud in the accounting department for vendor conflicts of interest or fake invoices. Do those cases settle? I've seen many of those cases settle, yes. What if it's key tam and the dollar amount of fraud is not much? So key tam tends to settle. And key tam firms, I mean, they're on their game because there's a lot of money in that, even when it's lower value. There's a lot. Big money is like bounties in that field. So like those firms, like those, they try to come here and be like, hey, can you give us like key tam cases, key tam, and like they're trying to like take us out and buy us stuff and like anything they can do to get referrals. That's how much those cases are worth. So yeah, those cases absolutely settle. Disguise 2023 Safety says, should there be separate compensation, or can there be separate compensation for spouse signature? For the spouse signature. So just to catch you all up, Disguise 2023 has some kind of settlement going, and Disguise 2023, they want disguised spouse to also be subject to a non-disclosure agreement, but they're not offering compensation to the spouse. You can demand compensation for the spouse. They might agree, they might not agree. Certainly. Thank you all for hitting the like button. We now have 26 likes and 34 concurrent viewers, and that makes me feel wonderful. What do we have? Open-minded. YouTube user Open-minded says, I have a right to sue notice, but I am still employed. That's why many attorneys are not taking my case, as it is not serious enough. But one attorney offered an hourly representation. Should I? Generally, hourly representation for workplace discrimination or workplace sexual harassment makes me uncomfortable. It can get so expensive so fast. I mean, listen, if you feel very confident in a case and you feel very sure that you're going to win, you're going to get paid on this, then yeah, you can pay hourly if you want. Certainly, there are very wealthy individuals who pay our firm hourly because they don't want to give us a percentage on their case, right? So we'll have people who make, 600, 700, 800K a year, 3 million a year, whatever it is. And they look at us and they're like, you want a percentage of my case? But if you get me 3 years, that's 9 mil. And you get a piece of that? I don't think so. I'll pay you a couple $100,000 hourly. You run the case. Do I love that? No, but I got to do it for them. I don't get a choice. It's not my preference. I would like to have a piece. I mean, can I get a piece? Piece to your case? Like, clearly that's my preference. But, in those situations, it makes sense. For most people, hourly does not make sense. Open-minded says, should I write my own demand letter, try to settle it before suing? If you can't get representation, sure. Time for a little bit of water. Got to check the emails really quick. One moment, everybody. I apologize. What do we got? There's a, without disclosing anything about any case, there is a gentleman who is like at some employer that potentially our firm might pursue. And he did some bad things. And he is checking my LinkedIn profile like every 30 minutes. But I guess he doesn't know that you can put it on anonymous or like whatever. So he just shows up and looking at my profile like every 30 minutes. It's bizarre. All right. Questions. YouTube user Chuck P801 says, hello. If you have audio and pictures and witnesses, but the lawyer says since the employer hasn't fired you, there's no damages. Is this true? So Chuck P801, I don't know, right? It depends on the case. You still might have emotional damages. You still might have punitive damages. You might have some economic damage. They might be low. I don't know the situation. I don't know what happened to you. I don't know if you're treating with a medical I don't know if you're treating with a mental health professional. I don't know what's going on. So I can't say the value of your case. And a case valuation is going to take a couple of hours. So I can't offer to do it for you. But I would say, generally speaking, I do not agree with attorneys who think that you have to be fired for a case to be valuable enough to be brought. I do think not being fired changes the economic damages significantly on a case, but that is not in and of itself a deal breaker. I've never seen a case won at trial that won less than 100K in emotional damages handle anyone within my sphere. Now, I know it happens to other people. It's just never happened in federal court to anyone that I know of. So I'm a little skeptical of this idea that like if you don't have a big economic damages verdict potential, you can't take the case. I don't agree with that. Crystal Bell says, okay, so how do you handle the EOC taking no available time slots for an intake appointment? Should I seek an employment attorney in the meantime? Yes. Get your attorney early and often. You don't need an intake interview at all if you're represented by counsel. They can handle everything for you. YouTube user Jamie Jasper says, huge corporation, lots of people involved in retaliation. Thoughts on aiding and abetting retaliation claims against individuals along with the claim against the corporation. If you're aiding and abetting claims, you have protections against retaliation because you are opposing discrimination and or retaliation. So that is noble and you have some protections in play, but it can be risky. YouTube user I'd like to go there podcast says, also, is that a real podcast? Where would you like to go? I've got many thoughts of where I like to go. Applied for unemployment insurance for not being paid from July on. They stated they are providing a severance. Could the unemployment insurance claim affect the severance? No, the unemployment insurance can't affect the severance necessarily, but I mean, they could say it does. They could decide that it does, but it wouldn't. There's no legal reason why it has to. The severance could impact the unemployment claim. Chuck P801 says, would you be willing to listen to my audio? Chuck P, me personally, super duper no, but you can call our intake and they will absolutely listen to it for you because that's a potential case and they would want to know if it's a case that we could make you an offer of representation on. In terms of me doing it for freezies to help you out, not a chance in the world. Don't have the time, couldn't do it, doesn't make sense, not going to download the files. Trojan virus risk, we have to go through a whole security protocol, it takes forever, can't do it, sorry. Kinsey, YouTube user Kinsey says, Kinsey, as in like the researcher Kinsey? Interesting. The EEOC Human Rights via Workshare is about to begin interviewing employees part of their investigation. Wow, that's big. Can you expound on what happens from here and if this is a good indication? This is a great indication. The idea that the EEOC is actually doing something. So I guess it's not. The Human Rights Division, probably you probably mean the New York State Division of Human Rights, I guess. They're having a fact-finding conference. They're going to be talking to people. Yeah, it's good they're investigating. That's really positive. Vera, Chuck, and Dave says the company I work for is overseen by a BOD. BOD? What role does BOD play in a nonprofit discrimination employment case? I think I'm missing your acronym. What is a BOD? What is a BOD? The CEO is also the president. Does the EOC consider them the voice of... Oh, board of directors. I'm an idiot. Okay, board of directors. The company I work for is overseen by a board of directors. What role does the board of directors play in a nonprofit discrimination employment case? They can pressure settlement or choose not to settle. They have a lot of power over it. The CEO is also the president. Does the EOC consider them the voice of the board too? No. The CEO is not the voice of the board. The board has its own voice and can remove the CEO as they wish in most circumstances. Steve's True History and Knowledge channel says, appreciate it. If I was in your area, I'd hire you. I'm in California. Yeah, Steve's True History channel. Local counsel is always a great option. We're in all 50 states, but local counsel is cheaper than us. So you should talk to local counsel. I agree completely. KKYYYMMM says, Kim, can becoming a whistleblower impact my discrimination case? Depends what you're blowing the whistle on. My employer has committed criminal offenses against me and other former employees that could be reported to the government. I think, listen, the criminal offenses, if you can show they were being done to you because of discrimination, because of retaliation, would be potentially beneficial to your discrimination case. And those police reports might be valuable evidence. I would talk to your attorney about it first. But yeah, I think it'd be helpful. Open-minded says, on average, how long does it take an attorney to write a demand letter? So different attorneys do different kinds of demand letters. We do a long narrative demand letter, and it's collaborative with our clients, meaning they get multiple drafts of it. They review it for accuracy, and that it sets the tone they want. And it's not, sometimes people are like, whoa, you are a little too aggressive here. Like, can you take it down? I don't want to kill these people. I just want a payday, right? So it's a collaborative process for us. So you're looking at a drafting attorney spending. So you get a timeline, a narrative from the client. You distill that down into a letter. You draft the letter, hitting only the high points, the scariest points for the employer. Client reviews, partner reviews, maybe I review in certain situations. Combined 14 hours, maybe, of attorney time between everyone. YouTube user Jamie Jasper says, if a manager retaliates and they have a violent criminal record and publicly posted threatening things about the past employer and workers, has, a bad temper and whatnot, does that show this person likes to get even? I mean, you can make that argument. I don't think it's the best evidence, but it's certainly a piece of evidence. It might convince a jury of that. I'd want more. If you need to prove that they tend to retaliate, I mean, that's a tough path. Like, proving somebody did retaliate is much easier than proving they intended to retaliate, right? YouTube user Diesel says, hey, I was curious if I'm kind of screwed. After settling my case, I've had 2 separate job offers randomly rescinded. It's quite depressing that a company would be so spiteful like that. Diesel, I don't know. I mean, do you have mutual non-disparagement, a neutral reference, confidentiality in your settlement agreement? Odds are, if you do, they're probably not outing you. But you could always hire a third-party reference company to check to see what kind of reference they're giving you. Chavi Chav says, since my employer didn't send a position statement of the charge of discrimination, I was planning on sending a grievance complaint, including retaliation, not in the charge. Do you think that's a good idea? Like filing a grievance with your union? So you file with the EOC. I'm not sure I understand the idea of then filing a grievance with your union because they didn't file a position statement. I don't know if I understand that. YouTube user Open-Minded says, how do I calculate my emotional damages properly? Well, you go to our damage calculation playlist and you watch a variety of videos on the topic of emotional damages and you try your best. YouTube user Diesel says, hi, Mr. White. I took a practice LSAT and I got about 160. I want to get to 170 if I can. LOL. Diesel, you are a more intelligent fellow than I am. I would say that. I think I topped out like 163, and it was a different era. I think your score is higher than mine because I think your 160 now might be worth more than my 163 back in like 04, 05. I don't know. I don't remember. Maybe 04. I don't know. Oh, should have muted that. Sorry. My story is still being written says, why does the EOC not take time to interview employees and they just go ahead and give the attorney the right to sue? Because the EEOC is a defunct agency that is not properly funded, filled with government employees who don't want to do anything. Choose Compassion says, do possible monetary compensation... Okay, so monetary compensation available doesn't really change whether or not you are a nonprofit or a for-profit institution, generally. So, like, in really, really big cases, you can have situations where nonprofits can't pay because they're just not funded like a Walmart, right? But generally speaking, for most claims, it's not a big issue. Exec Monster X says, if an arbitrator shows racial bias and makes a ruling that ignored the collective bargaining agreement and rules against an employee, can that be remanded in state law claim with a longer statute of limitations? So, okay, a couple of issues here. First thing, if you think the ruling for the arbitrator was what we would call arbitrary and capricious, in New York, you can go to a state court judge and say, hey, that arbitrator made an arbitrary decision. I know, it sounds weird. The arbitrator made an arbitrary decision. The whole point of an arbitrator is that the decision is supposed to not be arbitrary. It has to be well-reasoned, right? So you can try to overturn that arbitration decision. There's a very tight window of time to do that. Wherever you are, you should check with local counsel about your options for overturning an arbitration decision. Now, if there's racial bias in an arbitration decision, you can also potentially address that. In terms of ignoring the collective bargaining agreement, I don't fully know what you mean. You're going to have to check with local counsel about that. But I think what you're saying, instead of all that, is you're saying, hey, can I just go ahead and file different new claims under the same set of facts under state law? And maybe not. I'm not going to tell you definitely not, because I like my license. And wild stuff happens sometimes. But I'll say this. Generally, there's this notion of not giving you two bites at the apple. So you already had your case on this set of facts. Filing under a new law in a different venue would be viewed as a second bite at the apple, which is often something the system doesn't want to give you. They don't want to try the same set of facts twice. So whatever claims you brought with the arbitrator, even though you don't like how it went, you might not be able to do it again. But check with local counsel. Diesel says, how can I get practice in law prior to going to school? How can I get practice in law prior to going to school? I find it nearly impossible to even get an interview at a firm, given my background is as a software engineer. Yeah, Diesel, I mean, that makes sense. You could always try to find work as a paraprofessional, but it is tough to break into this industry as a non-attorney for obvious reasons. We value attorneys because they can do the attorney work, right? And non-attorneys can't do the attorney work. So we hire attorneys, right? YouTube user V says, why don't employment attorneys take federal sector cases on contingency like they do for private companies? Because the federal government designed a system to make it incredibly expensive and time consuming for employment attorneys to take on federal employee cases. Generally speaking, most firms that take on cases of workplace discrimination or sexual harassment for federal employees will at least charge something up front, often in the range of tens of thousands of dollars. And then they might also charge a percentage. And it's just because the federal government knew very well that it wasn't that great of an employer in terms of how it behaves, and that there was going to be a lot of claims against them. So they designed a system where they wouldn't have to deal with too many of those claims. It's harder for those people to get representation, right? Choose Compassion says, what are the risks? Whoa, chat jumped. I gotta go back. All right. Choose Compassion says, what are the risks of settling with a part payment plan from the respondent? Yeah, payment plans are always a risk because you got to collect, right? And if you think they're going to pay it out, then that's a great deal. If you think they might not pay it out, well, that is not a great deal because collections work can be rough. YouTube user Calm Giraffe. Hi, my manager reduced my hours, but she added 10 hours overtime for herself, only when I Zol. Yeah, so if there's discrimination in that decision, Calm Giraffe, then that's a potential claim. But if it's just she wanted overtime and she wanted you to work 10 hours less, then that's probably legal, maybe, depending on if you have a collective bargaining agreement or something like that. Kid Godsu says, hello, been watching your videos as of recent. I was fired from my job while on family medical leave act time, while also winning a workers' comp lawsuit versus the same company. Filed MCAD lawsuit. What do you think? Sounds like a claim. I hope you have counsel locally. Also, is your username a reference to the Korean term of skill, gosu, popular in video gaming circles from the early aughts and late 90s? Are you a Brood Wars player? Did you professionally play StarCraft? Susie B says, what is the timeline for filing a New York State human rights law complaint? My case took place in February 2023. Think I missed the opportunity. So no, the New York State human rights law has a 3-year look back. A 3-year look back. So you would still be timely to file your case in state court. YouTube user Justin says, just got in here. What are some tips my employer wants to settle before mediation? Justin, check out our mediation preparation playlist. Also, check out our settlement negotiation playlist. Those are going to be incredible places for you to get started. Vera, Chuck, and Dave says board of directors. Yeah, absolutely. I caught on after a second. Vera, Chuck, and Dave. I'm sorry. John Doe KCK says, hey, I got the last 10 minutes. You sure did. John Doe, it's good to see you. Diesel says, today's team just announced they were removing their arbitration clause in their subscription agreement. Any idea why they would do that? Yeah, Diesel, because of Disney. I saw that too. So Disney effed up something fierce by trying to force a family that got hurt somehow into arbitration because that family agreed to arbitration in their Disney Plus wrap-up agreement, click wrap agreement. And the optics of that were horrific. And Disney got roasted. Disney has gone from being this juggernaut of industry and just so smart in how they handle everything to just oh my God, we are dismantling this company day by day. It's incredible. It's fascinating. But yeah, I listen, I don't know why Steam dropped their arbitration clause, but I suspect that may have had something to do with it. YouTube user, whoa, chat is jumping. Okay. YouTube user open-minded. How likely is it that big media corporations would rather settle than be stubborn and go to litigation, even if they feel they can win? Listen, most cases in this field settle. Let's just be honest. Settlement is the norm in this field. Yeah. QQ Bella says, can the employer reject arbitration? Well, QQ Bella, it depends. Are you subject to an arbitration agreement? Are they subject to an arbitration agreement? You can offer arbitration if you're not, but they don't have to say yes. However, if you have some kind of contract that requires you to go to arbitration for this kind of claim, then potentially no, depending on how that clause is drafted, potentially no, they can't reject arbitration. Water. Email. See if that guy checked my profile again. Okay. Back to the live stream. Okay. EMW. YouTube user EMW says, I filed an EOC disability discrimination claim against my employer on July the 15th of 2024. They have since requested an extension after a no response remediation. Now I'm waiting for an investigator to be assigned for EEOC. All right. Well, I wish you luck. YouTube user Shay. I was terminated 25 minutes after submitting a sexual harassment grievance to HR. The employer's claims they made the decision to terminate me coincidentally at the same time I emailed HR. Yeah, that's a hell of a claim, Shay. You should get an attorney right away. That is a valuable claim. YouTube user case says, how long after you submit your rebuttal should it take for a new movement in the case? So if you're at the EOC level, anywhere. So if you're represented by counsel, I would expect things to be happening in terms of settlement negotiations, discussions about pulling your right to sue letter and going on to federal court, discussions about next steps. If you're not represented, that case could sit for 3 months to 2 years, unfortunately. Choose Compassion says, hit the like button. Thank you so much, Choose Compassion. Thank you all for hitting the like button. We have 34 likes on the stream, which is how people find our stream. And we have 46 concurrent viewers, which is not bad for 6 p.m. on a Friday afternoon. Yo-Yo Dine, YouTube user Yo-Yo Dine says, hi, Vince. What are your thoughts on revealment letters? Hi, boss. I filed an EOC charge against you. So I mean, I don't like personal letters from the plaintiff to anyone because most plaintiffs are not, like, they know you. So the unknown can be much scarier than the known. They don't know me, right? They know a character version of me that's like this monster for hire that, like, I traded away parts of my humanity to create. And so when I threaten them, it might go well. You know, they might be like, oh, Christ, this guy's such a piece of shit. Like, he's going to ruin my life. What am I going to do? When you do it, they might be like, Yo-Yo Dine, the guy who, like, eats spinach for lunch, is threatening me. How do they respond to that? I don't know. Yo-Yo Dine. The answer is I don't know. Kid Gosu says, yes, that your name is a reference to the Korean term Gosu, and King Godsu was not a pro player of StarCraft. I mean, listen, we all can't be XDS Gur, can we now? So many questions about what servers and channels you played on, but we won't hijack the live stream to talk about StarCraft from the 90s and early aughts. Courtney Zinke says, do you have to say on your application if you broke your leg? Also, do you have to claim that as a disability? So a broken leg isn't a disability unless you need an accommodation, right? If you need an accommodation to do a job, then I mean, it's potentially a disability depending on where you're at and what laws you're using. And if you need that accommodation, I wouldn't include it in the application. I always tell people to get the job first, then ask for the accommodation. I know that, like, lots of employers are like, you lied to us to get the job, which I just hear as they wouldn't give you the job if they knew about the accommodation. So, like, get in the first and then ask for your accommodation. I don't care what anyone else says. All right. Whoa, channel jumping. Open YouTube user open-minded said, this 350 hourly attorney is the only local one who is willing to take my case. I have the money to pay, but my hourly work pay is $19. Can I possibly break even if I'm very reasonable in my goals? Open-minded, if you are earning $19 an hour and paying an attorney $350 an hour on a case that could run up hundreds of hours, I am very nervous for you. I don't love that for you. That worries me quite a bit. Diesel, YouTube user Diesel says, what do you think about mass arbitration? I think it's the only answer in certain situations. There's some kinds of claims, right? If you have, I don't know, 1,000, like more like 100,000 claims against Spotify because Spotify, I don't know, had a data breach. Okay, how are you going to do that? Mass arbitration. That's the option. That's the play. Do I think it's a great thing for employees? Generally, no. I don't think class actions are a good thing for employees either. I think class actions get, and for that matter, mass arbitrations get the attorneys paid, and the victims, the employees in class actions, don't tend to get as much. Henry Best Believe, what's the best way to show a timeline of events happened related to your case? I would like to show something visual. Okay, so Henry Best Believe, this is firmly in trial attorney territory. And so when you go to trial, one great question to feel out a trial attorney is like, hey, what visual aids are you going to have created? And a lot of them will look at you and be like, none, we don't need that. And I don't love that for you. I would say potentially you need to talk to somebody else to do that trial. But the next answer is going to be, oh no, we do video purely video aids. And that's good. And you should do that. You should have video aids. But you should also have physical aids. And I'm going to tell you why. Bailiffs are lazy. And they will leave physical aids in the courtroom while the jury is bored. Often, very often. So your visual aids could end up sitting there for multiple days of trial. And the jury has nothing to look at. They can't have their phones. They can't, there's nothing to entertain them at all. So what are they looking at? Well, your video's not playing. Your video's not playing. You know what is still there though to look at? Your visual physical aids. So yes, you should create visual physical aids and have them in the court with you. Listen, there's a million different ways to do that. I have preferences. Other trial attorneys have preferences. The simplest is a plotted line with times and dates and list of witnesses and pictures represented of what happened, or, you know, blurbs of text that are really visually, you know, popping, or like wild headlines. Like that's the simplest way to do it. I don't know if I'd say it's the best. It can be the best. It depends. It depends on your case. It depends what you're trying to show. It depends on how many things you have to mark. It depends on how many elements you have to prove, right? Like, and how many different data points you need the jury to keep in their brain for them to accept that you've met the elements, right? So listen, that's situational. It's also different from trial attorney to trial attorney. It's different from how you want to use it, but you should have video aids. You should have, if you can, audio aids always, but also you should have a physical visual aid in the courtroom, or plural. The more of them you can have, the bigger hassle it is for the bailiff. And the bigger hassle it is, the more likely it sits there. And defense counsel might take it upon her or himself to get up and try to move your aids. And you run over there and be like, yeah, you're not the bailiff. What are you? Stop that, Steve. Stop it. Stop it. Leave it alone. And you gosh, get away from my shit, Steve. No touchy. I can't hit you, but leave it alone. Right. And it all sounds silly, but like the value of having a physical visual aid sitting in the courtroom for days. I mean, is that worth $1 million? It sure could be. It really could be in this industry, right? John Doe KCK says, in the EOC proceeding, is it good practice for the plaintiff attorneys to prod defense counsel for mediation after the formal request for such was sent to the EOC? Yes. Yeah, I don't think there's anything wrong with talking about mediation with defense counsel. King Godsu says, what areas do you practice in? What states? So we do workplace discrimination, workplace sexual harassment in all 50 states. That's it. Nothing else. Chuck P801 says, because you're the man, fam, helping everyone. Thanks, buddy. I hope I am helping. Viral Shedding Zombie says, does Vince have a nice tan, or is that at studio lighting? A little bit of column A, a little bit of column B. Thank you for noticing. Music Underground says, can we ask a question? You sure can. That's what I'm here for. You got about 55 minutes left to ask a question. YouTube user Open-Minded says, if a news organization can prove they did not discriminate, would they choose to settle out of court to save their reputation because they can expose their unprofessional work environment? I mean, I'm not super inclined to answer that question because I help people who are actual victims of workplace discrimination and sexual harassment. So like the idea of making a bullshit claim to get paid is kind of like antithetical to my life's work. So I'm just not going to dig in there. I'm sorry. Justin, as an employment attorney, what part is the biggest risk, and do attorneys get intermediated by bigger firms? The biggest risk is that we spend a ton of money on cases and we don't always win, right? There's no guarantees in this field. You can spend 80, 90, 100 grand on a case and lose. And client's not going to pay you, nor should they, right? Like you got this big percentage on a case because you thought you could win it and you spent big and you can lose. You can lose. Also, listen, you can spend a lot of money on a case and the client might just one day be like, I'm a liar. I lied. They're not going to give you back your money. You got to sue them for that. You're going to pull some water out of that stone. It's not going to happen. Those are some pretty big risks. And again, 99.9% of the claimants in this field, the plaintiffs in the field, are honest. That is not what I'm saying. I'm saying that stuff happens sometimes, and that firm's never getting back that money. Ever. YouTube user BMM says, if we forget to add a statement or reference to response of a motion for summary judgment, can we file a motion to add it a couple months later? Yeah, you can amend. You can amend your motion as long as it's still open. Listen, it might make the administrative judge angry, as your attorney said, but it depends on the situation to some extent. YouTube user Diesel says, do you ever get nervous in front of the judge? I definitely did early in my career. I can remember very specifically a very nice judge would refer to me as Sweet Cheeks, and that made me a little nervous. But she was always really, really great in terms of how our cases went. So, you just kind of, hi, Judge. Whatever you got to do for the client, right? What do we have? We have we have YouTube user Dre up next, who says, I have an interview with the EOC Tuesday. What should I ask? What should I look for? And how is the mediation process after the interview? I already made a complaint with OSHA. So we have a mediation preparation playlist that you should take a look at. There's a bunch of videos in there to get ready for the EOC mediation. In terms of what to look for, make sure you're hitting your elements in your interview. Make sure you know the elements of your claim. What are you trying to prove? And then go about showing that to the EOC in that interview. That is the most important thing. And also, we have a whole playlist on the EOC process that you might want to hit up. YouTube user YoYoDine says, thanks, Vince. I recall you stating in some past videos that you do reveal as a representative fairly quickly. Oh, yeah. Usually people hear, if you hire our firm, the employer probably hears from us in like 48 hours, 48 to 72 hours, I would say. It seems like legal notice would make a challenge to decision maker knowledge. If I understand you, yes. YouTube user BMM says, continued, this statement we forgot can prove the defendant's LNDR for one of the claims. I don't fully understand what we're continuing, BMM. But you can amend. You can potentially amend your motion for summary judgment. If it's important legally that you do so, then it's worth it. If it's not, then your attorney might be right. What do we have? Henry Best Believes says, my whole process from the incident to write up to suspension to fired to internal appeals process was drug out way too long. Yeah, that happens. Certainly. Gotcha. Kinsey, happy to help. I thought you were the wrong Kinsey. I apologize. YouTube user Case says, can you move your case to your home state where you worked if you filed in the state where the corporate office is situated? Maybe. You certainly can try. I mean, it makes more sense for the case to be in the state where you worked in most situations. What effect could it have on the case? Well, you're going to have different laws in different states. You're also going to have a different jury pool. So you're also going to have different availability of employment counsel. So lots of different things. King Godsu says, my question, my investigation hearing is scheduled next year. What happens until then with a lawyer and without a lawyer? So statistically speaking, if you have a lawyer, what happens between now and your hearing is little north of 98% of the time the case settles. If you don't have an attorney, all bets are off. If the case doesn't settle, some amount of discovery and trial preparation will take place, depending on what counsel you have or whether you're doing it yourself. Ray Bethel says, how close to the trial date can you hold out for a better settlement offer, and can you submit a bottom line settlement offer? You can absolutely submit a bottom line settlement offer. That is often called the last best demand. Now, in terms of when you can settle the night before trial, you can settle the morning of trial, you can settle in the middle of trial, you can settle as the jury is filing in to give their verdict. You can settle after the jury is given a verdict. When the other side says they're going to appeal, you can still settle. You can settle at any point. Music Underground says, what should I do if my current counsel is only going for wrongful termination, but not my wage and discrimination side of my case? I'm only preparing for mandatory arbitration. What should I do? Well, sounds like you can hire a separate attorney to handle the discrimination and wage issues. If that attorney that you have is taking only wrongful termination to the arbitration, then those other claims might still be available, and you can just hire a different attorney for them. You could also talk to your attorney about bringing all the claims in one action. That's, some options. I would schedule some consultations and a conversation with your current counsel to figure out what's going on and how to go forward. Exec Monster X says, follow-up question. Can an arbitrator's ruling be challenged under a breach of contract, under a state law claim, which has a longer statute of limitations? I don't know. What is your contract with the arbitrator that you'd be challenging? So I guess the answer is, if you have a contract with the arbitrator of some kind that the arbitrator is breaching, I guess I can see how you'd bring a claim, but I don't really understand what contract you would have with the arbitrator. You could have a contract with the employer that requires you to go to arbitration. That's very common. That would just be the arbitration clause, right? Whatever agreement that arbitration clause is in, that contract would, be controlling. But I don't know what contract you would have with the arbitrator. That would be strange to me. It could happen. I guess I could imagine a circumstance where you'd have a contract with the arbitrator who's handling the arbitration. It just usually wouldn't be the case. Also, you're seeing tons of planes and helicopters. The UN is right behind me, and they are going wild this week. This is UN week in New York. Everything is a disaster. All the restaurants are full. There is security details from almost every nation on God's green earth, and they're just everywhere, and it's ridiculous. And the NYPD is losing their mind and being very aggressive. So that's what's going on. What do we have? YouTube user Yo-Yo9. Whoa, chat jumped. Where a plaintiff has not been able to find counsel despite effort and has filed pro se in federal court, when is it appropriate to move for appointment of counsel? Is one time better than another? Listen, if you think you can get the federal court system to appoint you counsel, move immediately. I think that's somewhat unlikely in this field, but give it a shot. If you think you have an argument, definitely. Jamie Jasper says, is a company in a highly regulated industry more likely to settle if they think the lawsuit could get picked up by the media? Yes. Simply yes. Excuse me. A Trauma Center, a place for healing, says, hey, Vince, is a conflict of interest if the agency counsel also participated in the decision-making process that led to some discrimination? I would argue yes. And I have forced counsel out on a variety of occasions for things similar to that. YouTube user Diesel says, how is AI affecting this industry? I've heard of court reporters using AI to transcribe depositions and stuff. Is this going to dangerously impact the field? So Diesel, I did a video on this recently. I think that a lot of, you're going to see a strange effect where larger firms and firms with more resources who can invest more heavily in AI over the next 5 years, not today. AI is trash today. All the AI legal drafting options right now are hot garbage. But in 5 years, I expect they're going to be pretty good. And what you're going to find is that certain firms are going to be able to afford them, and those firms are going to be able to take more cases. And so the richer firms are going to get richer, taking more cases. But the smaller firms are not going to be able to do that. And my fear is that many of the smaller firms are going to go extinct and not bring as many cases. And so there's going to be a consolidation, which will benefit me a lot, but will harm potential claimants who, like, people who might not be able to hire our firm might go hire like Johnny and Tina down the block. And Johnny and Tina might only be able to scrape together 30 cases a year, but they might work those cases pretty hard. And they might help those people, you know? They might not make a lot of money because they're not getting like hiring clients or big cases, but they are helping people and they're making a living, right? And they're helping 30 more people that would not have been helped because the big firms take the big cases with the big money. And if you got a big money case, you don't probably hire a mom and pop firm because you want a firm that can throw a lot of resources at your case, right? So my fear is that AI might have a trickle-down effect where a lot of the smaller firms get extinguished, and that means that some plaintiffs are not going to find the representation they want. Blockboy D says, does your job have to honor your doctor's note by saying you can only work 40 hours? If you have a disability that requires an accommodation of only working 40 hours per week, then yeah, under the ADA and potentially state and local law, depending on where you are, that would have to be honored. YouTube user Shay says, got any recommendations for good employment? Can't give you recommendations. Our malpractice insurer has been clear. If we refer you to other firms, they feel that is a potential source of liability for us if that firm does something wrong, and it would impact our ability to, well, they would be very upset about giving us malpractice insurance if we're just referring you to people. So I'm sorry. YouTube user Open-Minded said, as you said, a case could run 100 hours and be risky for me if I'm paying hourly. In that case, focusing on settlement only would save hours and get me out of the financial risk. Yeah, I mean, listen, you could hire that attorney purely for settlement purposes, certainly. YouTube user Y says, my job is retaliating against me. Whoa. For use of a line for an LOA. Denied my accommodation and covertly preparing to fire me. How hard is it to prove covert things like isolation, refusal to assist with work needs, and so on? Not hard. I mean, listen, it's always situational. Depends on what's going on, but like that is routinely proven in many cases. Extreme FX 2010 says, Family Medical Leave Act retaliation. My manager tried to write me up a PIP while I was on the Family Medical Leave Act accommodations. Put more work on me, had a trauma relapse, now in a long-term disability case. Sounds like a claim. Yeah, talk to a local counsel. Choose compassion. For those wondering about time frame with the EOC or Department of Human Rights, I can only say it took mine almost 3 years, just my experience. Yeah, I think it is much shorter if you have representation. On average, a lot of our cases resolve in that 6 to 9 month window. But, you know, if you're not represented, it certainly takes longer. QQ Bella says, thank you, Vincent. Employer hid discipline document in a personnel file after a lawyer got involved. Does it make them look bad for hiding discipline paper during the lawsuit? Yes. Natural Intellectual says, since my separation notice only states severance and not performance issues, how can this affect a potential wrongful termination claim? So in most jurisdictions, wrongful termination is not a claim. It can be in certain circumstances, in certain jurisdictions, but in most of the country, wrongful termination is not a claim. If you're talking about workplace discrimination or workplace sexual harassment, those very much are potential claims. And your employer failing to note any performance issues is beneficial for those claims. Exec Monster, generally speaking, every situation is different. Exec Monster X says the contract is between the employer and the union under the collective bargaining agreement that arbitrator is supposed to enforce. Exec Monster X, I'll say this. I don't fully understand the legal argument you're trying to make in that scenario. Doesn't mean you're wrong. Not saying you're wrong. Just saying casually, as a hot take, the legal argument you're trying to make with 30 seconds of thought doesn't make sense to me. But 30 seconds of thought is only 30 seconds of thought. I'm not saying you're wrong. YouTube user BMM says, defendant initially had 30 days for the motion to summary judgment, then requested a 15-day extension. However, they failed to file a motion for summary judgment. During the pre-hearing conference, the administrative judge asked her to file a motion for summary judgment and gave 45 days for it. Is this normal? Yeah, it's a really bad sign. The administrative judge thinks that some portion of your case will get dismissed or wanted for some reason the motion for summary judgment to be filed, but the most likely reason why that person would want the motion for summary judgment to be filed would be they want to get rid of some portion or all of your case. Justin says, damn, I wasn't subscribed on this device. My bad. Justin, it's okay. We forgive you. Also, we have 55 concurrent right now and 39 likes on the channel. Thank you, everybody. Thank you so much. What do we have here? Whoa. Oh, well, we're caught up on questions. We might call the live stream. We're caught up. Any more questions? Get them in, folks. We're wrapping it up. Oh, wait. No, I jumped ahead. I lied. There's a ton of questions. Chad just jumped to the end, and I thought I was done. And I was like, I can go home. I can go home. Okay, what do we have here? YouTube user Open-Minded says, if the EOC dismissed the case because they could not go further back to link my current discrimination case to past events beyond 1 year, can that be done after I file my lawsuit within court procedures? So it sounds like the EOC is making a statute of limitations argument that they can only look back 180 or 300 days, depending on what state you're in. And also, depending on what state you're in, the look back for state or local laws may be far longer. So the answer to your question is yes. If you file a lawsuit under state and local law, in addition to your federal claims, then yes, the look back could be longer and you might be able to look back further, and that might be good for you. YouTube user Ladybug777 says, howdy from Texas. Howdy from, well, I'm in New York right now, but usually New Hampshire. The Trauma Center for a Place for Healing says, how can you get counsel removed if there's a conflict? You can raise the ethical issue with the judge or the agency or the arbitrator. Or you can, if you need to, file a grievance against that person for the ethical issue. YouTube user 22JDog says, good job. Thank you, if you're talking to me. YouTube user Diesel says, do lawyers have settlement authority for malpractice insurance? What? Do lawyers have settlement authority for malpractice insurance? I know that workers' comp, the company does not have authority, only the insurer. However, the doctors have settlement authority in theirs. Oh, I don't know. I've never had a malpractice claim, so I don't know, Diesel. I should know that. I don't know that. I don't know if the malpractice insurance can settle a claim. Like if somebody filed a claim against me, I don't know if the malpractice insurance company could just choose to settle it or not. I've never had to find out, and I hope I never do. NYC Damages says, glad to make this live. Thanks, Vince, for all you do. You're more than welcome. I don't do much, but I'm happy to help. Diesel, why do doctors have more power? I think, Diesel, maybe because their licenses can be impacted, so they might require that in their contracts. But I don't know, Diesel. I don't. That's a little outside my purview. NYC Damage says, when the EOC investigator says they're talking the case over with the commission, who do they refer to? Is this per local office? And what can you do to get a better result with that investigator? So the commission, listen, I don't know where you are, but in New York City, the New York City Commission on Human Rights it's a city agency. So the EOC might be saying that they're collaborating with the New York City Commission on Human Rights based on your username, which is NYC Damages. That's the most likely person they're talking to. In terms of what you can do to get a better result, ask to present evidence to that investigator. John Doe KCK says, wait, you have malpractice insurance? Yeah, attorneys carry malpractice insurance. I thought that was only for those practicing medicine. No, you get accountants with malpractice insurance. You get lawyers, doctors, obviously. There's a lot. YouTube user Sonia Underwood says, hey, Attorney Vance. Vance is a cool name. It's not my name, but it's a cool name. Question, I followed your advice and found a local counsel. I'm glad to hear that. That's amazing. Oh, this is interesting. I followed your advice and found a local counsel, but he said he's in a big case right now and asked if I could have the case moved to the beginning of the year. ... What? Question mark, exclamation point, question mark, exclamation point. Yeah, that's a little concerning. That does concern me a little bit. I don't know. You're asking me what? I don't know what. I don't know that person. I certainly didn't refer to anybody, but that's a little concerning. I share your concern, I guess is all I can say. I don't know that it's damning. I don't know that it means that that's a bad attorney, but if this person is representing you, first and foremost, they would be the ones who would be moving the case around and adjourning the case. But more importantly, like, that's interesting. It's an interesting ask of a potential plaintiff. YouTube user Kakila Cooper says, in a sexual harassment and employment retaliation case, what happens after discovery? Well, summary judgment can be filed, or it may or may not be filed. So discovery includes your depositions. Those are all done. Once it's all wrapped up, you might have a summary judgment phase where you fight about whether there's going to be summary judgment in the case, and then you're going to be scheduling trial dates. You can also talk settlement in the meantime. YouTube user Send Me to Law School says, in a discriminatory retaliation case, the suspension with pay consider adverse action by the court. Let me read that again. In a discrimination and retaliation case, the suspension with pay, is suspension with pay considered adverse action by the court? So, lots of disagreement on this. Right off the bat, defense attorneys are going to argue, well, you're getting paid, so it's not adverse action. However, we have to look at, did you have the same access to your bonus pool? Did it hurt your opportunities within the business? Did it isolate you? Did it limit your ability to gain promotion? Did it limit your access to the decision makers? Like, there's a lot of things that I would argue are adverse, even though you are being paid. Extreme FX 2010 says, want to say thank you for your service and videos. Well, I wasn't a veteran, if that's what you mean. No stolen valor, but I'm happy to help in any way I can. That's not true. I'm happy to help by making videos. YouTube user KRP says, hi, Vince. I have a pending appeal, pro se, in the Second Circuit. Pro se appeals are super hard. I'm really sorry. On average, what are the chances of succeeding? I've never seen a pro se appeal succeed. I'm sorry. And that's just me personally. It doesn't mean they don't succeed. I've never seen one. YouTube user Jamie says, company offered $30 to settle. Want a response in 24 hours. Counter back with $47,000. No response from them. Oh, okay. Misread. Jamie said the company offered $30,000 to settle and want a response in 24 hours. Jamie then countered with $47,000, received no response. I mean, listen, I think must have some leverage if they want to give you some money. Choose Compassion says, could being a pro se litigant make your case possibly take longer simply because other people have attorneys? Yes. YouTube user Shay says, do you think the employer would have a great chance at my charge being dismissed due to the fact that I actually have been late multiple times? Although they never termed me until they made a report to HR. I mean, listen, you being late a bunch is not great for you, but the fact that they never disciplined you for that until you made a complaint to HR, like, if that complaint was a protected activity, I think you have a pretty solid argument. YouTube user XY Duke says, at mediation, should damages reflect potential trial value, $500,000 in 2-3 years, or current value, $120,000? We asked for $120,000, but I want to start negotiations at $500,000, settle at $120,000. Reasonable. So it's a little bit in between. Usually, if you're talking settlement, you are hedging for risk. Now, that being said, you don't know how long you're going to be unemployed unless you've already mitigated, right? If you already mitigated, the damages are the damages. You kind of know what the economic damages are. But if you haven't, well, the future's unwritten. And I think you can argue you're going to be unemployed for a long time. That may or may not be true, but you're going to argue it. YouTube user Yodo9 says, should a plaintiff address or respond to the judge as judge or your honor? Your honor. Always your honor. Only attorneys who are a little bit familiar should really be saying judge, in my opinion. NYC damages. Should employers keep quiet that an employee filed a complaint with the EOC still in the initial process and no negotiation settlement yet? Yes, they should keep it quiet. Why? The EOC requires that your job has an open dialogue to discuss your disabilities and how to help. Is it legal? Is it illegal if they don't? Yes. If they fail to engage the reasonable accommodation dialogue with you, that is a fundamental failing under the law. a dialogue. If you ask for an accommodation and they fail to grant you that accommodation and they fail to give you the dialogue, those are two different ways you can win that claim. Justin says, can multiple attorneys work on your case? Yes. And that's true within the same firm. Many firms are going to assign multiple attorneys to a given case, but it's also like some people will have multiple firms work on a case. Generally, that gets kind of messy. I don't love that, but it happens. NYC Damages says, open-minded, look into ongoing harassment, which can come back longer. That is true. There's certainly a continuing violation doctrine that you can look into. Yeah, you can amend an open EOC filing. That's not a problem. Trauma Center is a place for healing. Vince, as agency has in-house counsel, wouldn't it be better for your industry to get involved sooner? I only ask because a lot of attorneys want the ROI or the right to sue. Yeah, so I have been saying this for years. Hire the attorneys early and often. The attorneys should be happy to get involved early. We get a big percentage of your case. Do the work, earn the fee, like get in there early. Like I don't buy this wait for the person to get a right to sue letter nonsense. I think it's nonsense. I am running out of steam. I'm gonna be honest with you. I'm getting a little tired. So I'm gonna just run through, answer a couple more, and I'm gonna call it a day. I've been going about an hour and 35. And I am just out of juice right now. Out of juice. Okay. To the questions. Henry Best Believes says, I was suspended for something I didn't do. Then one of the reasons they said they fired me is because I didn't improve since my last write-up. Okay. Jorge Zelaya says, hi, Vince. If someone was wrongfully terminated due to a disability on June 15th and found a job August 30th that pays more, does this affect the value of the case? Yes. Your economic damages will stop growing when you took the new job, but you will still have emotional and potentially punitive damages. What do we got? YouTube user Ernest Simmons says, I live in Atlanta. I'm trying to find an employment attorney. I also called your office 2 weeks ago. Ernest, I hope that Intake good care of you. Hope that Intake took good care of you. There are good employment attorneys in Atlanta. I know for a fact. I'm not allowed to recommend any to you, but I know there's a couple of really good ones in Atlanta. And I hope you had a good experience with our firm if you call their Intake. Justin says, how often do you do these? We watch your videos, but to interact is awesome. Generally every other week, but I'm trying to do them more often. I think it is important for me to do these, but it's, it's tough. It's tough to find the time. Sonia Underwood says, thanks for answering my question. I have the shakes, LOL, smiley face. I'm reaching back out to your firm. Sonia, I would not, just between us, talk about your communications with our firm on the internet. Just my advice, just my thought. And I'm not trying to in any way. I just think it's safer for you if you don't. Mohammed Irfan says, can a religious worker eligible for portability of job while I-45 is pending for the 2 years? I'm sorry, I don't understand your question. I think that might be an immigration question. So I don't do immigration work, but the I-45, I believe, might be an immigration form. Exec Monster X says, the arbitrator's decision made a ruling in favor of the employer, but never gave a reason. How can I go about obtaining that information? So Exec Monster X, at least in New York, an arbitrator's ruling, and I work as an employment arbitrator for the American Arbitration Association, has to be well reasoned. So they have to create a document explaining their reasoning. If there was no reasoning or no stated reasoning, you would have a better argument, at least again in New York, and this is different in every jurisdiction. So check with local counsel, but you'd have an argument that the arbitrator's decision was arbitrary and capricious because they didn't give their reasoning for the decision, right? So I would look into that. You can probably call the arbitrator's office and ask for the reasoned decision. Oh, I'm sorry. So Ernest Simmons, I'm sorry I was cut off. Did what I say to you not come through? I'm sorry about that. I was saying that there are some good employment attorneys in Atlanta. I'm not allowed to recommend any of them to you, but you have some good options. And I also hope that when you contacted our firm, that the intake people took good care of you. I know the call center was getting overwhelmed recently, so we've been taking steps to address that. Yes, these live streams, I tend to try to do them on Fridays, although I recently have done a few on like Thursdays and Tuesdays. I schedule them when I can. It's hard for me to know when I'm going to have the time to do them. Diesel says, I've heard stories about people using bullshit reasoning and quoting completely irrelevant laws about parking violations and then not being able to appeal or overturn an arbitrator's decision. I have not seen that. I will say that. And that would probably be something that you could argue is arbitrary and capricious and get a judge to overturn. All right, last question I'm going to answer because I feel wiped out, and it is Friday at 6:40. Oh. All right. Last question. NYC damages. What to do when the employer is sharing someone filed an EOC complaint? Well, I would have your attorney threaten them and say, I think it's going to be way worse for them if they keep running their mouth. Like, that would be my suggestion to you in that scenario. Certainly. All right, everyone. Oh, last question. Mohammed Irfan. Employer doesn't give the Social Security number, tax, and benefits. What should employee do? Contact the Department of Labor and the Taxation Authority right away. That is my recommendation. Okay, everyone. I hope you have a lovely weekend. It is Friday, 6:40 p.m. for me. I'm going to cut this off. You're all wonderful. We have 50 concurrent at some point. We have 40 likes. You all make me feel special and happy and pretty. Yeah. Hope you all take care. I hope good things for you. I hope that you all don't need to bring cases, but if you do, I hope that you win. And I will be back soon. I hope. Take care, everybody.